unfunded, And definitely there are consequences for failure to do certain things. For example, reporting, providing your information and everything, and failure to register, and the criminal liabilities are there. 15,000 for the first month, depending on the threshold that you fall in, and all those kind of things. And let me say that because the Tax Act and the GAIN of the interventions that come with components of consequences for non-compliance, then your questions become very relevant in that directive. Personally, I would say that these legislative instruments are necessary. They are necessary strategic interventions where you have a country like Nigeria, where you will find out that the government can only thrive on tax as it is in every other nations. However, I think in ensuring that we drive millennium development goals, we must also be mindful of the fact that a portion of the population who are informal workers needs to be captured. And the only way this can happen is when the economy is better for everybody. So I want to believe that the incrementals, the slight incrementals in the tax structure right now are not unexpected. That's the truth. Except we want to start beating ourselves over, nothing. So there's a burden that is visible. There's an incremental for those of us who are earning above a million. But did I say some of us? Sorry. For those of us who are earning beyond 1 million, so there's an incremental. You're supplementing tax for, you're paying tax for other people.
So that's
so there's a burden. However, let me also say this, that I would expect that as Nigerians, perhaps what we should be concerned about, apart from compliance, is the fact that perhaps we must start to drive home holding government to account. It is necessary that to whom much is given, much is expected. And then we must call into account those who are collecting these monies. A higher degree of accountability should be there as well. And perhaps we must start looking at, perhaps we should demand for the justiciability of the fundamental objective and directive principles of state policy, particularly when we are seeing that people are going into this poverty line, despite the fact that there's a certain level of tax increment. But for me, I think it is a necessary strategic intervention. It is strategic, and that strategic intervention must come with some burdens for some of you who are going to be paying more than you earn. I'm sure a lot of us now see that when you're
one of us, sir.
When you are sending monies to people now, they will tell you that look, you must include the purpose for which you're sending the money, so that if it is a gift, if you're purchasing something, the tax man, because right now they have your evidence and everything is clear on the purpose for which the money is paid. And you will find out that, let me tell you the true good thing. We have always expected that this president, from what he has achieved in Lagos State with IGR, I was not in doubt that this was going to happen. And because he knows the importance of automation, automation is the only thing that drives compliance now. So it is important that corporates must be automated. I'm going to come to this later in subsequent discussions. But I think these are the major highlights of the GAIN and the tax law and the tax act. Let me say that for the other interventions, the pension, for example, what it seeks to do is to enhance dignity for retirees. These are just policy interventions. The discussions around them are still on. It aims to broaden access to improve service delivery and improve pension assets for dependable source of financing, and particularly to improve the level of investment that comes with those who pay. It also tries to improve health insurance premium, for those who are covered in the pension scheme, and, just to drive in what seems to be a dignified pension life for pensioners. For the National Industrial Relations Policy 2025, it is one that is developed, to promote stable, harmonious labor relations, particularly where you have unions and you have fledgling national companies like your Dangote. We all knew what happened when the nation was almost going aghast with the fact that, look, the unions were going to cripple Dangote and all that. So I think one of the core objectives is that it provides for structured dialogue that strengthens cooperation between government employers and workers. It also tries to bring to life workers' rights and safeguards for fair wages, safe conditions, and international alignment on how you have discussions over disputes that arise from from labor relations and industrial relations as well. It also promotes social dialogue and encourages people to come in to give suggestions, to give, and of course it discusses rights protection. But as I said, whether or not this is going to succeed depends a lot on mutual trust as between government and the unions. I think and of course the bigger corporates, because I think the element, in fact, when the paper was being worked on, I saw somewhere that Labour actually withdrew from those discussions, believing that, look, some of the things are still not adequately covering some of the pushbacks, but that the Labour people are bringing. So I think from a whole perspective, the GAID and the tax law, they are necessary legislative interventions, and I'm not surprised that they come with additional burdens, both for corporates and for individuals. Thank you.
Thank you so much, sir. So, I mean, if I hear you correctly, the laws are and the regulations have been set in the right direction. We expect that the harmonization, of course, if we hold government to account, the harmonization of the tax law, the implementation of the data regulation, of course, sets the corporate entities and, of course, employees in the right direction. And just that people that earn more get to pay more under the tax law.
Absolutely.
And then people that pay less are just really sitting comfy. But you are saying, let's encourage people that earn less, to come up the cadre and earn more. Yes, I would come back to you, sir, after I asked Nancy this question. You will speak more as to the informal bills, because yes, if people earn more, they will pay more tax. But of course, the informal bill speaks to pension and how we want to ensure that persons are included in protecting their future. So I'll come back to you to speak on that. But I mean, to take a dive into the industrial relations, and I mean what we saw in 2025 with Pengasyn and Dangote, and we all felt we knew, I mean, how this was going to end. We all knew Pengasyn is one union you do not joke with. They seem to be one that always won every battle they ventured into. So, Nancy, I mean, in view of how that, issue was resolved, what do you see? I mean, in your opinion, what was really the dispute here? And that resolution, what change has it brought, to industrial dispute resolution, especially when it comes to union matters? Well, what's your take on that?
Okay, thank you, and good afternoon to everyone. So if you look at that particular dispute, you could see that the dispute did not start in court. You could see that it actually started from poor communication. You could also see that the trust has been broken, because the truth is employment problems actually begin in work. So not even in court. So when it goes this way, employees complain. And when they complain and they feel ignored, they feel nothing has been done. So what happens is they run to their union. And what union does, union gives warning. And when they give the warning and nothing is still done, then that's when you see where strike follows. So when employees feel ignored, what happened? They look for power somewhere. So that's what you actually see in what happened in that particular case. So in my own opinion, I would say that the problem started long before we even heard about it. So you could see that what really went wrong, there was dispute across the same issues. And what are these issues particularly? You could see that, for example, now employees were excluded from major decisions. Communications they were like lack of communication, or the communication was not even clear at all. So agreements were not even implemented, or either they were not even implemented on time. So they've complained and there was no feedback. And this thing moves this way. You could see internal complaints, union involvement, warning, strike. So now let's look at this particular case. What really happened? What really made it possible that the government had to come about it? How it started was the dispute did not start in strike, like I said. There was mass dismissal, there was allegation of union exclusion, there was actually concerns of replacement. You could see people actually, they were actually agreed labor. There was different things coming out from that particular case. By the time the strike action has actually been declared, trust has already been collapsed. So there's disruption of fuel, government intervention, there was court order, there was emergency negotiations. So you could see that all these things would have been avoided from day one if the right thing was being done. If the right thing was being done. So that's why you see that when workplace engagement fails, everything is now left in the hands of the union. And the lesson here is actually simple. You can't exclude the union, especially in an organization where the union is very strong. You can't exclude the union, because if you exclude the union, they will escalate. But once you engage early, you start everything on early, you could see that there could be change. So these are the kind of things you could actually see that all these things happen, and it didn't happen. It was when we started hearing about it. That's not when it happened. I'm sure these people have been complaining. They've been talking to the management, but the management just felt like, oh, they can't do anything. And by the time you make the union, and this thing is simple, you go to union, and union give you a warning notice. If you ignore them, they'll make you understand that that's why they are union. They'll have to do what they want to do to show you that they have powers. Because these people, they pay their dues, they pay the union dues. And you don't expect them to say, oh, like, I'm paying dues and I come to you for a problem and you cannot solve my problem. Tomorrow, they won't pay that same dues. So these are the things the management have to understand, that you can't just on your own tell employees that, oh, you can't join union. It's their right. They have a right to join association, and which association they have. The ILO convention is there for them. They have a right to join association. And the management was actually understand that. And you cannot turn to an employee because of the employee join union, oh, the promotion is not there, you're not going to do this. They're going to run to their union, and union is going to fight for them. So most of all this dispute we are seeing now, it can be avoided, because I'm sure they must have complained. That's why the management, the HR, once this complaint has been raised, let's not just throw it under the carpet. Let's deal with the complaints. Let's find a way to, what's the complaint? If it takes to investigate, you investigate about it and all this happens. Because if the management decides to ignore this complaint, they're going to spend more, because they're going to go to court. They'll get a lawyer. They're going to be back and front. Their businesses are going to be disrupted. They've lost money. They've lost trust. They've lost every single thing. The reputation of the organization has gone down. So with what happened with this Dangote's case, I think the management, even the organization, should learn from it, that we shouldn't wait till when it gets to strike before they act. They can actually act before the public even knows about it. That's my own opinion with what really happened for that particular case. Thank you.
Thank you so much, Nancy. I mean, yeah, because it was Pengassin, government intervened. And I would come back to you, because it then seems that when it is ASUU, even though they are dealing squarely with government, we don't have the same swift intervention. It seems that ASUU can go on strike for 8 months. I think they were on strike for 8 months in 2022 or 2023. Okay, and nothing came out of it.
Okay, for that particular one, we have to be realistic. So how many of these government children go to public schools? They're not affected. But when it comes to this particular one, everyone has to drive their cars. Everyone has to afford their generator.
So it's an economic stability thing.
It's actually going to, because, let's be sincere, in the country we find ourselves, whatever is not affecting the government, they don't move. That's the truth. But ASUU is not affecting them. That's what they can do, like to 8 months. So imagine if there's a law passed in the country which says that all public servants, all government officials, you must school in Nigeria. Your children are not allowed to leave this country. And there's an ASUU strike. They know their children are not in school for 8 months. They know what is going to happen to them. The government will do something about it. So ASUU is a different resident doctor strike. So you can see that many of them that most of them, once they are even the easiest Panadol, they fly to London. So it's not affecting them. That's why you see that strikes like this can prolong. Why strikes like this particular one can't prolong? Because it's affecting everybody. It's affecting the low-income earners. It's affecting every single person. But if you see the ASUU strike and the resident doctor strike, it only affects some categories of people. I would actually say maybe the middle class or the low-income earners. I would actually say that. But this particular strike affects everyone. So anything that comes to this particular union, it shakes everyone, and the government moves.
Thank you so much, Nancy. And I do know that I'm supposed to ask my learned silk about, decisions in court, but I just thought to bring this in, for the learned silk. I mean, how do you then strike the balance, between the issue of economic stability, as Nancy has raised, and then the labor rights? Because Pengassin is a union, HASU is a union. They are both unions that are supposed to get equal opportunity to have interactions with governments, get their issues addressed, and ensure that they do not have to go on strike, go on extensive strike, or even have that policy of no work, no pay, as we have implemented with HASU, as we have implemented even with the doctors when they go on strike. What is your take on this? I mean, I do know you represent some of these unions, at times. How do you balance it?
Thank you very much, Titi. I'll throw the question back because I'm sure I heard Nancy rich and incisive take an intervention on that. And it would not be fair that you ask me to still make comments, except to say that, okay, let me use one of the appellate flourish that you read when you get to concurring judgment. She said it all. I have nothing useful to add. I agree with that. And well, if I could just chip in one or two lines, still riding at the back of what she has beautifully and lucidly captured. She drew up an analogy. One union sneezes, and because of his hold on the mainstay of the economy, the nation catches cold. And as such, it dictates that you should listen to them. The other union, the traditional chalk, they just write, and then who cares whether they resume to school or not? So that can actually take some time. I think that's what she, in addition to expressly saying that we should read in between the lines. That's the answer and all of that. Thank you so much.
Thank you, sir. So to bring it to these decisions that we have in court, I mean, why do unions fight? They are fighting for their rights. They are fighting for their take home. And most of the reasons why people go to court is because they feel my rights have been breached. I ought to get compensation. Now you see that in past decisions, if you look at the past 1 year, it seems that the law has, the courts have shifted in the kind of compensation they now give out. And if you look at one of the recent cases, beyond even the quantum of the compensation, we now even have them relying on new laws that seemingly there have not been any decision on compensation on them. The Special People's Law of Lagos State in the Jagun and Ethel decision, that was indeed the very basis of the claim of the claimant, and it was on the basis of that claim, that the decision of the court was rendered, giving him some entitlement, not based on any other law but that. What is your view on the move, the rise in the compensation regime as we have in the courts?
Okay, thank you very much. Thank you very much. Well, I thought that after listening to the insightful and incisive interventions of GOB and Nancy, all you just asked me to do is to go to the chat box and just try and claim my CPD point, as some persons have been filling their details. I didn't know you still want me to take on one or two things around the issues that have come up. Let me start first by congratulating Ellen for putting this together, and by extension, the launch of the publication. I've taken my time to read, and I must commend the editors for putting together a beautiful publication, reviewing not just the landscape in 2025, but also offering some insight and forecast into what 2026 holds. And this takes back, in some way, this relates to the question you've just asked, the concern about compensatory damages, with special attention to the case you've mentioned, and the fact that compensatory damages, the regime was not extended to cover what some law prescribe. If we're to look at it from that perspective, I would say that there's nothing wrong with the decision. We shouldn't forget that the practice of the law in this part is adversarial. It is what is brought to court, and the opposing sides have an opportunity of canvassing opposing views on that the court would make a determination one way or the other. It is not meant to be inquisitorial. It is a few times that the court can sort of try to dissent by asking parties to address what would appear to be a knotty jurisdictional issue. And if the judge would also not bring it up, again, you still cannot blame the court because, like I hinted, it is adversarial. So what was submitted before the court, the head of claim was largely built around the Special People's Law of Lagos State. Now, the Special People's Law of Lagos State has gone into what, in a review that I did, I felt that the House of Assembly lacks the legislative competence to make a law that deals or is in an area that falls within the exclusive legislative list and is not covered by the concurrence or one that falls into, or that can straddle into residual list. And to that extent, Lagos State House of Assembly should not even have made that, could have made that law, but the sections of the law dealing with the regime of compensation that would attend upon industrial accident and unfair treatment of the employee in the workplace. I think that was beyond the breadth of what the State House of Assembly can look into. More particularly so when we already have laws made by the National Assembly within that area, starting from the Labour Act, going into the Employment Compensation Act, going into Factories Act, and quite a number around that area. So that is the concern about that. But beyond all that, and I don't think that is even the issue, if we are looking at compensatory damages or the concern around that, I think the major issue around is not necessarily flowing from that particular decision. But what, in my view, and reading the cases and going through the cases, would appear to be a lack of prudential guideline or the depth of prudential guideline as to guide the court without necessarily fettering the discretion of judges to consider peculiar fact situation and make a determination one way or the other based on the claims as proven before the court. What would appear to be the ever-recurring question of consistency and proportionality in the award of compensatory damages in employment dispute generally. And when I look at this, I look at it from the perspective of compensatory damages in the event of workplace injuries and industrial accident on the one hand, and compensatory damages in the events of special cases or instances for which the establishment statute or act of the court, coupled with the expansive provision in 254 of the third alteration, have given the court to, in certain instances, award damages that could go beyond the threshold of what before the third alteration was the position. So that's a concern. On the one hand, when it comes to the one in industrial accident, you have instances where a claimant in one particular case suffered severe injury that costs 2 fingers, permanent loss of 2 fingers. And the same set of facts, or in almost the same situation, happened in another fact situation that was determined by another court. In both cases, the said injuries were said to have arisen from the employer's breach of duty of care. Despite this, the quantum of compensation awarded differs significantly. So that gives a concern that should that have been some prudential guideline to ensure that there is predictability and certainty in the law, which is what's the law. I mean, the common law involved and time-honored principle of determination of cases in the adversarial setting have always been about. Whilst facts and surrounding circumstances may justify some degree of discretion. Such a wide disparity gives concern and reiterate the growing need for prudential guidelines to inform the assessment of damages. And this is particularly so where we're concerned about a court that we commend is doing a whole lot in the new world of work in ensuring that standards are brought at par with what comparably should be what's obtained elsewhere, international standard. And the need to ensure that it is a court that is taken to be not just industrially informed court, but one whose decision, when it gets to what either was the Intermediate Court of Appeal, but it's not the final court dealing with labor and employment dispute, would always look into and say that we can't fault this. We would agree, and then we will let the position be. So that is the more reason why it's important that whatever that court is doing, there's some prudential guideline that guides and doesn't leave room for the appellate court, the final court, which is supposed to be a court of policy. It's not supposed to be entertaining appeals dealing with the evaluation of facts. And that's the way it works in the two-tier appellates, in the two-tier court system. The court of first instance is really the final court for evaluation of fact. The appellate court just look into issues of policy, or when they say that the application of the law to the fact or peculiar fact differs significantly from what would have happened or what happened elsewhere. So this is the time, or this is the more reason why it's important that what they are doing is consistent and is proportionate to what similar courts, similar fact situation, when it comes up before the same court, howbeit before another judge, they get to arrive on at the same conclusion. So that is one area that gives concern. But having said that, I also know that in as much, and still looking within the area of industrial dispute, in as much as that court has tried to still consistent with being able to offer a remedy where there's an injury and it is shown that indeed this is due to the common law, breach of a duty of care on the part of the employer. In as much as the court has tried to be consistent, I shouldn't think that there are times when you find this inconsistency because even the court cannot tell how the appellate court would treat such judgment when it comes. And saying this, and I'll give a particular, I'd like to draw from a particular example. Around 2009, 2010, thereabout, I remember that there was a judgment that came from the NICN Ibadan division. It had to do with this gentleman who worked with one of the electricity distribution companies, and was a technician who had gone to climb the electric pole, and somebody had forgotten to put off the power switch. Long and short, he got electrocuted. He survived it, but he survived more like a vegetable. It was reduced to something close on that. The limbs were gone, the legs were gone. And in the judgment, the particular judge, in evaluating the fact, I remember that specifically wrote there that when the gentleman was brought to him in court, he had to look elsewhere. He had to look away. That for one moment, emotion overwhelmed him as a judge, because all he could think was that this is a man, or this is someone who's been reduced to a vegetable who would always need someone to help him get a bottle of water and help him to take it in his mouth. When he goes to the bathroom, he needs someone to assist him do anything he wants to do. So he's been reduced to, he basically, his expectation of life and all of that is really been cut off. He's just living. And at the end of the day, I think they claim, so the courts made all those findings, which I felt were very good and justified making an appropriate quantum of damages that, quote unquote, one could say is a large to compensate him. But at the end of the day, what happened was that I think they claimed, maybe they asked for 200 million and the court awarded 50 million. When I read that judgment, the review for 2010 that I did, no, maybe 2012, this was 2011. the review of the cases, I commented on that and I critiqued that particular portion that, look, the judge, I think the judge failed in applying what was meant to be the appropriate quantum for somebody that you had said that clearly he's still, expectation of life, he was still meant to, he was in his prime, and you expect that on the average, he still has maybe at the minimum of 20, 30, 50 years to live, and then all you could sum up was 50 million. There's a need to always take into account the inflationary trend, what Naira was changing for when it's taken against the currency of the world, the currency of the world dollar. And all of that, all of those factors should be taken into consideration. And the judge was wrong as far as I was concerned that it was a case that called for judicial scrutiny at the appellate level. I never saw the judgment, so I didn't know that case had traveled to the Court of Appeal. Sometime 2020, thereabouts, I just got a notification of the judgment of the Court of Appeal that was sent to me that, the judgment of the lower court that had criticized should have been, the quantum should have gone higher than 50. The Court of Appeal frowned at the 50 that was awarded and reduced it to 20 million.
So I mean, in view of this uncertainty, and knowing fully well that now when we file in court, the higher the sum you are claiming, the higher your filing fee. Hold
the breath. The question I also would like to pose, I mean, permit me to put it back to you now, is that, so you could take it alongside what you also want to ask me. The rationale for that, and the concern of that Court of First Instance, that if I go higher, even though I'm justified in the judgment, if it gets up, what if the Court of Appeal, not only will the Court of Appeal say you were wrong, there are instances where the Court of Appeal would even come down heavily on the judge that, you missed this. You should never have thought of this and all of that. So that concern, you can never take out. I recall before the third alteration came, the judgment of the Supreme Court in one of the cases where Justice, some case where the argument that had gone to the Supreme Court was whether in the circumstance of the fact situation that happened, and somebody that was wrongfully terminated in a circumstance that really compelled the court to look beyond that threshold of a month's salary in lieu of notice. When the argument was submitted, or Shison and African, that's the case. When the argument was submitted before the Supreme Court, I recall that what Ogbuagu said in disagreeing with the trial court, who even tried to go beyond the 1 month salary and awarded more, for which the Court of Appeal reversed and ended up at the Supreme Court. It was now being challenged at the Supreme Court. Ogbuagu just said that, let it be known that there are particular areas of the law that are now within a very narrow confine, the understanding of it, and that certain statement or certain understanding of the law remains sacrosanct, that everybody must have, that you don't even come to court and canvass anything different. That as far as quantum of damages is concerned, in an employment that is master servant, common law has dictated that once the servant has been wrongfully terminated and is successful in an ensuing action filed in court, the quantum would only be what he would have gotten if it had been properly terminated and nothing more. If that was all the Supreme Court said, one would have said, well, I mean, the Supreme Court was only limiting to what the position largely influenced by common law was, and never saw a day when there you have 254. But the interesting thing is that in that same judgment, some people had gone further to say, in fact, this is a note of warning to lawyers that any time in the future a lawyer tries to come before the court, the final court, to canvass that in employment, in a master-servant relationship and wrongful termination, damages can go beyond that 1 month or whatever it is that was contracted, that was not paid, and you are asking for in lieu of notice being given, that such a lawyer would, in addition to losing the case, the court will come down to find what costs against that lawyer personally. So you have judgment like that still fly. And then as against this, you have judgments like that largely influenced by common law, pre-tort alteration, that the court, even though is at the bottom of the ladder, the court of first instance, as a judge, is human to also think through that, well, in as much as I want to do judicial activism, or I really want to strike the position of the law beyond this, I have to be careful what you will say upstairs and all of that. Sorry. So
uncertainty is what we should expect, because my question was tailored to the fact that when we file processes, the filing fee increases in view of what you claim. And so what should be the guide? I mean, and I think that's what you try to answer in your second intervention, to basically say, lawyers, be guided. Don't ask for things. I mean, before you prepare your pleadings, read decisions of courts, in respect of this issue before you come up with your claims. And maybe what we also need to begin to do is that we need to, of course, put on our thinking caps and ensure that the claims we put up is such that arguable when presented can be granted by the courts. Would that summarize it, sir?
Absolutely. But in addition, we should also know that all things being equal, we are approaching a court that the Constitution has given some wild expansive power that no other court has in Nigeria. If we look carefully, a calm reflection on the lettering of the sentences, the phrases, the wording of Section 254, the whole of the ambit, you know that indeed you are likely to succeed, or you may succeed in pushing what within our local circumstances we would have thought that that's the only thing you can push before the court. If you can show that, yes, international customary law, it obtains elsewhere, and it is now international best practices. So there's no reason why we cannot have similar things. So yes, we put on our thinking cap and stay within the ambit of the law, but nothing stops us from traveling abroad, seeking what the courts have said in similar circumstances and coming before the industrial court to put it across. I think the rule says as long as it's pleaded for that.
Thank you so much, sir. I mean, sincerely, I think as a litigator, every time I go, or I get to draft a court process, and I want to come up with claims that are not just situated in general damages, I go and read related cases. And sincerely, that's a guide every practicing litigator must deploy from time to time. You just don't, come up with claims. You ensure that your claims are such that when presented, would hold water. So let me come back to JB. I mean, it seems that we speak to structured workplace, we speak to companies, but bringing it back, to regulations and policy. In 2025, we have the Informal Sector Bill passed, and in time past, employment has been seen to be, very focused on persons in the formal sector. But it then seems that there is a move, to have an inclusive employment policy in place. How do you see this policy, or better say, this law being implemented? And do you think persons in the informal sector would really be captured, or we just have something on paper that largely would not be implementable, by government in this new dispensation?
Sorry, I was muted. Thanks.
Yes,
the Informal Persons Act, that law is itself a very good. I mean, I like the fact that we have started. Maybe we have not hit where we're going, but we have started, and it's important that we have started. That act protects and regulates employment of vulnerable persons, particularly domestic workers, apprentices. So you will see on the road as you are traveling, you could see a boy just working for a vulcanizer. That boy is about 10, and he's just rolling a tire and just putting on the machine. Those are the kind of people. You have people in markets who are just carrying one thing for their orga, so to speak. The bill essentially domesticates an international convention, the Domestic Workers Convention, which is a treaty that encourages national governments to protect domestic workers from violence and abuse. So essentially, it says that, look, you can't employ somebody who is below 18 years. If you go to England, you'll find out that most footballers in football clubs who are not 18 are in an academy where they're going to school, so they will not give you a contract, so to speak. So you will be in school, you'll be studying, that you'll be playing for what they will call a feeder team. That does not suggest that you're working for a living. It further provides that people who fail to comply with with employing people who are less than 18, will face imprisonment of about I think it's 6 months or 500,000 naira. It criminalizes physical abuse and what have you not, provides for a centralized. So essentially, one of the key drivers is that, we must capture those who are vulnerable by way of a database, by way of having their names, their details, including their fingerprints into one detail. You see, the challenge with this seeming radical legislation is capacity, which you have said. And before delving into capacity, I don't think the bill was considered in a manner that reflects our what I'll call our traditional way of doing things. I always say that way before now, our traditional systems were working. For example, we all know about the Igbo traders who have done what I call a succession planning with their business. Every Igbo man who sells spare parts, every Igbo man who sells, who has a what do you call it, a pharmacy, every Igbo man who has any business venture, not necessarily their sons, away from the fact that they will call it whatever and sons. They have a succession plan that caters for people who they bring from their village. These people might be a relative, it might be a friend's son, it might be somebody. Now, if you extrapolate this act into what those guys are doing, possibilities are very high that you might see them as violating some provisions of this law. So I'm not sure, because we've seen that Igbo apprenticeship system has actually progressed into a way where you can find people become their own business owners. I've seen apprentices who are now on 2-3 shops. They have not even employed people who they have brought up as a measure of what they learned from their former boss. So I'm not sure that this act takes into cognizance the fact that there are traditional systems that have sustained succession planning in business over the years, and they may be seen as violators. Also, in the north, they have a system by which they cater for their own people who they see as as vulnerable. And this system has worked for them, such that, in fact, if you come to some places in the north and say you want to take data of those people, they will chase you away. So there are practical problems that relate to some of the enforcement provisions of this legislation. Now, let us go to the capacity problem. Where are the officers who are going to go all over Nigeria to even capture these people? I don't think they exist, and I don't even think we have the numbers. Who are we going to do a house-to-house enumeration of words? Where are the biometric machines? Are we going to go to the markets, for example, to start picking vulcanizers and start picking this? I'm not sure. I'm not even sure that, look, this thing has been well thought out in a manner that could see a well-structured manner of how to enforce and to not just enforce, in fact, to administer the legislation in itself. Additionally, I think, for me, we have tried to use a legal solution for what I consider is a social problem. That people are vulnerable in Nigeria is not a legal problem. I think it's more of a social problem. And social problems are solved socially. I'm not sure you can carry a stick to beat a child who is crying after you have beaten that child. That's not the solution. You need to call that child and now say, okay, after beating you, let me tell you why I have beaten you. I think it is important to start looking at engagement and using people who can reach vulnerable people to bring them out of, or government itself should try as much as possible to implement actions that will bring people out of poverty. The reason why a lot of people are vulnerable in Nigeria is because of poverty. And unless we start to now bring them out of poverty, I mean, let me ask you, if you drive along most of the major roads, you see mostly northerners who are begging, whose children have been brought into the employment of begging. It has now become employment. Those people are vulnerable. How are they going to be captured? Are you going to imprison their parents who themselves are well below the poverty line? So I am not sure that this is well thought out in a holistic manner, in which case you are trying to solve a social problems must be solved socially. We must employ experts. We must employ thinkers. We must look into where the root causes of poverty is and then try to lift people out of poverty rather than legislate, to punish people. For example, some of us have people who are living, whose parents have willingly given them to people to live with. They know that because you're in the city, and they don't even mind the person going to school. It is enough that the person is feeding, is being clothed, and is exposed to the social life of the city life. Then are you going to say that that person who is helping that child survive, knowing that if that person goes to an Ogbomoso or into somewhere inside the learning, that person is just going to be useless for the rest of his or her life? So I think it requires a lot of rethinking. I am not sure the way it is worded, in which case you want to do, and this is where it is funny in Nigeria. Nigeria is a funny place. Let me tell you, there might be isolated cases where you see a child run into a police station and start to complain that, oh, I was just being beaten at home. Police will go to that person's house and they will bring out this legislation, and that person will be sent to jail for it. But whether or not that solves the problem is another thing entirely. And I don't think this is the way and manner to go. Unfortunately, it is the law. Please, I will advise that we should advise people as much as it is possible to comply with it as much as they can.
So, I mean, to summarize, what you're saying is, if this bill passes, it is a legal solution to a social problem, and it doesn't solve anything in itself.
It doesn't. Absolutely.
Titi,
Wow.
Sorry, I know you don't ask me. Let me just add what I think Gbenga so beautifully puts across. Sociocultural influences on the current not taken into cognizance, and as such, it's not a question of finding a legal answer or solution to what is that sociological related issue or problem in the society. But the fact that when it is passed into law, it is likely, very likely, to be a law, like many laws in Nigeria, whose letters are honored more in breach than in observance. I'll give an example. Child Rights Act and a few other laws and one other particular, I've forgotten now, stipulate the particular age a housemaid can be. A housemaid that you can have at home. What is the age? Otherwise, it imposes heavy penal sanction for an employer of a child who is not up to 18, or is it 21? Sorry, 21 thereabouts as an housemaid. Now, the interesting thing is that I saw a cartoon, so there was this cartoon that was made of it when that law was being made some years back. That the interesting thing is that when it was being discussed in the house, somebody whispered to another that, are you sure? Even you members of the National Assembly, if you go to your houses and all that, the housemaid you have, you don't have somebody that you brought from a village that is 11-year-old and is serving you and all of that. So we have those letters of the law criminalizing quite a number of things, and with the aim to seek to protect the vulnerable. But like Gbenga has also said, protecting the vulnerable is more about providing for the vulnerable. That's the best way to do. that's in the society, as opposed to letters of the law saying that if you employ these and then this will be wrong, or if you don't provide for this and all of that. Thank you.
Thank you for that intervention. And so let me stay with you in this regard. I mean, yes, I agree that this bill hasn't become law. And I mean, looking ahead,
I've been referring to it as an act. Sorry, it's a bill.
Yes,
Which is
it's still a bill.
I'm
Yes,
sorry.
Don't worry, sir. So I mean, it hasn't become a law yet, and our fear is immediately it becomes one. The way to implement it, I mean, we do not see it working. Yet we have a law in Nigeria that is very clear. I set out, I'm going to restraint of trade. I set out that if you want to restrain the trade, of someone working with you, 2 years is the maximum, statutorily provided. And year in, year out, we've had National Industrial Court uphold that statutory provision, of course, which was bet out of common law in itself. My question is this. Court of Appeal has now said, we know better. 5 years seems to be good enough. That Lakasera case, yes, isolated, yes, a lonely case in itself. Do we say it has overturned the 2-year statutory provision? Or do we say it's just a unique case in itself that we do not see in the year 2026 being followed, of course, by the National Industrial Court, that is bound to follow the decision of the Court of Appeal in this instance?
Okay. Thank you very much. I hope you don't put me in trouble, because that's a decision of the final court. I've written a critique of it, and I've been called to answer a few things around it, and I continue to maintain that that decision was reached by incuria. And I have no doubt that when next the Court of Appeal, that final court, by all means, court of policy in labor and employment matters, gets an opportunity to re-examine it, the courts would discard this bill and take a good look at it, discard, and follow what the statute has now made available in that terrain. But what is the starting point? So I have no doubt. And why do I say that? Let me just quickly say that before I come to the decision. There's a concern ever since that decision was made last year that seems to validate that an employer that seems to prioritize an employer's interest in preventing competition over an individual's right to work for as much as 5 years post-employment. Ever since it was made, it would appear that, indeed, as lawyers, we can now advise our clients when they are drawing up training bonds, restrictive covenants generally in an employment contract, that yes, there's no reason why you cannot seek to hold the employee down or prevent from having labor mobility, even for as long as 5 years after he disengages or he exits your employment. So there's a tendency to want to say that that position has been validated by the court, the final court, and that continues to be the position of the law. I would very quickly advise that that's a very dangerous advice, because we should not forget that that decision did not take into account Section 68 of the FCCPC Act that has specifically said that contract of employment, restrictive covenants are allowed, but cannot be anything beyond 2 years. And when we recall, and cannot be any, so that particular provision was not discussed or did not come up in that decision. And I reckon that when it comes up before the Court of Appeal, that will be brought to the attention of the court, and the court would no doubt agree that, this was reached by incuria. Let me draw a similar analogy as to why I am optimistic, not just cautiously optimistic. I'm highly optimistic that it would be upturned by the same court. Many will recall that when Section 12 of the National Industrial Code Act was made, Section 12 of the Act is the provision that gives the court some level of discretion in departing from the Evidence Act, application of Evidence Act in certain deserving cases or instances or circumstances in cases before the court. When that provision was made, indeed, the Industrial Court had relied on it many times to depart from strict application of the Evidence Act until sometime in 2016, when the Court of Appeal, again the final court, in second Ebelu-Boboso, said that, and I remember the exact wording of the justices, that as long as it is the Evidence Act, all superior courts of record in Nigeria, it must apply, including the Industrial Court. There is a strict application that, in other words, that position, that decision expressly said that Section 12 would not stand, and it was more like hacking it down, if we want to put it that way. That was 2016, and that remained in place for a long time till 2022. Now, 2022, Adegboye and UBA was made, and Adegboye and UBA said no, that this position was wrong because it did not take account of the provision of Section 3 of the Evidence Act that already says that the act would apply to test the admissibility and non-admissibility of matters submitted before court, except there is another legislation or subject to the provision of some other legislation dealing with the admissibility or non-admissibility. So that was really the basis of Adegboye, alongside other ratios that were raised to support that reasoning. But what is the interesting thing about it? That ratio that Adegboye came up with to depart from its earlier decision. And of course, Adegboye decided, in fact, brought frontally Ebelu-Boboso and SEC and discussed it that, oh, we didn't consider this provision in Ebelu-Boboso. So that's the reason why we're departing for it. The interesting thing is that this was 2022. Long before 2022, I said 2016, the decision was made. Boboso was made 2016. 2018, thereabouts, in Ubata and NJC, Honorable Justice Kanye, then presiding justice of the Lagos Division of the Industrial Courts, had written that indeed Evidence Act, despite the fact that there was a decision of the Court of Appeal that said that, oh, it must apply, that Evidence Act cannot apply in that particular case, for the singular reason that, and irrespective of the fact that, oh, the Court of Appeal has said that it must always apply, because there's a distinguishing factor that the court is considering here that was not considered in that case. And the distinguishing factor is that Section 3 of the Evidence Act in itself already admits that there might be instances where the court can say that, oh, because of the provision in another national legislation, then Evidence Act will not apply. And that national legislation in this case is the National Industrial Code Act. What is the point here? This was said 2018. It took 4 years later, the Court of Appeal agreed with what was said in that case, in another case. I think the same thing might happen there. Why do I think the same thing might happen? The starting point is for us to look into the philosophy behind restraints, contract and restraint of rate generally. And I had an opportunity of discussing this the other day with me, that the settled intention at every point in time is that the law says that it's a negative contract. That's the starting point. It's a negative contract. It should not be allowed. But also recognizing or deferring to the need to protect commercially sensitive trade secrets of the employer says that in certain instances, it may be reasonable. So it starts from the position of negative. It will be reasonable. It will be allowed if it is reasonable. Now, what has been the reasonability test? Reasonability test has always been considered as against the timeline, the scope, time for which the employer seeks to hold that employee post-employment. Whether it's in time of, oh, you cannot work within the same geographical radius or within the same sector for a number of time, you cannot disclose certain things and all of that. That is in all the cases that have come up before the court, that is how the courts have always considered. And in my small, I will admit, my small limited research of studying well over 53 cases, both local and international, from Commonwealth countries and all of that, I make bold to say that I'm yet to see a decision that upheld 5 years. And I think it was one of the reasons that informed the critique that I did. I'm yet to see a decision that upheld 5 years. Now, what is the interesting thing? It was a decision that summed up the Court of Appeal agreeing to hold an employee post-employment down for 5 years within 3 paragraphs. And it wasn't structured. There was no structured discussion as to the rationale behind it. One would have expected a reasoning, structured, analytical decision or discussion that would have been around it. But the interesting thing is that somewhere in between those lines, the same Court of Appeal relied on the 1973 decision of the Supreme Court in Kumuli's case, where for the first time, Nigeria court had an opportunity to apply or consider it at that highest level. That is the reasonability of accepting in a particular fact circumstance that the court was considering. Now, we all thought that cases are considered vis-a-vis the peculiar fact. Now, Court of Appeal was relying on a case that was determined by the Supreme Court in 1972. It's not the year that is the issue. It is what is the rationale for the expansive discussion that Udoma JSC then had, Udoma JSC had in that case. It was a restrictive covenant that sought to hold the employee down for 1 year. That's one. Beyond all of that, that decision relied on, it was 73, relied on the 67 Esso Petroleum's case from the UK. That was also in a similar circumstance, was the peculiar timeline there was 1 year. So the point is that how do you use HAPU, compare with Orange, and you arrive at the same conclusion? 1 year, 5 years, it's not done. So that on the one hand, let's even look at structural reasoning around it. And I still make bold to say that even in my limited research, and that's really at every point in time that I've had and I couldn't talk about it, that's always on the ask that, Amiga, I also want to learn. I just want to see a decision where the court has said 5 years, you can hold anybody down, irrespective of what has been spent. Nobody's saying that we should not look also to protect the employer. There are other ways. But what is quite shocking, let us say that for the purpose of argument, Kumulis even agreed with 5 years. Let's say for the purpose of argument, somewhere in between Kumulis, there was a discussion of a case that was for 5 years. This was 72. FCCPC Act came. Kumulis was largely based on common law doctrine, right? And the law is that once there is a statute that has now legislated a particular fact, circumstance, or social circumstance within a particular framework, that is what would always guide anytime such a matter comes up. Now, FCCPC Act is very specific in Section 68(1). You can't do beyond 2 years. So that's the other reason why I think that if it was brought to the attention of the court probably would have looked at that, considered that, and come to a totally different conclusion that because it was 5 years, and that was what the lower court was trying as much as possible to stress that, so yes, protect legitimate interests whatsoever to prevent competition by all means. But if what you say is to restrict labor mobility for 5 years, no way, it's not going to work. It's not going to work. So that's my thoughts. That's not.
I mean, to summarize a part of your thought is to say you envisage that in 2026 the National Industrial Court will distinguish, and will find a way not to be bound by that decision.
And the interesting thing,
peradventure, if peradventure there is the opportunity to return to the Court of Appeal, the Court of Appeal would find reasons to agree, with that department when Section 68 is brought to his attention. I think I agree with that.
Do you know?
But
Do
I
you know
mean,
the interesting thing? You did say that in 2026 that perhaps if we time travel to today, the Court of Appeal or the Industrial Court will find a way to distinguish. I can assure you that there and then in 2025, in Alilu and Chief of Naval Staff, it was one of the things that the court already said. That, oh, we are aware that there's a decision like I said that I said is 5 years, but in that case, Section 16 was not considered. So I can say much that a reason
thank you
to make
so
a
much.
distinction and arrive at a contrary position from what the final court has said has already arisen at this day. Thank you.
Wow.
So
Thank you so much.
Titi, if you will permit me 5 minutes just to,
I'll give you 2 minutes.
Okay, so quickly,
Strict 2 minutes.
One of the things I see with how we deal with restrictive covenants is the fact that we are trying to put strict numbers to what is defined or what is generally a factual situation. Folabi makes a fantastic description of what it is when he said that it is something that is dealt with on each fact of peculiar cases. It is so I find it a bit curious why a judge or a legislation is putting a 2 years on something that had several degrees of situations that could happen. Let me give you an example. And I think it's the fact that we are not thinking of the possibilities that could arise within a business line. First, bear in mind, there are 3 things that a restricted covenant aims to look at in considering whether or not it will strike down that contract. 1 is the number of years. 2 is the geographical space. And 3 is the proximity of the person to confidential information. Those are the 3 things. Now, bear that in mind. Now, let me assume, for example, that I become the general custodian, or I become the COO of MTN in Africa. I become the COO of MTN, overseeing the whole of Africa, right? And my covenant says, look, after 2 years, I shall not work for a competitor within Africa for 3 years, or for 2 years. Let's say 3 years in Africa. For one reason or the other, I left MTN and I seek to take up, and Google establishes an office in, no, not Google, let me say, what's this? Orange establishes a company in South Africa. And let's say I was sitting in Nigeria. Will it be fair to MTN within those 3 years that I go to Orange in South Africa? It is a poser. I will leave it at that. But you see, we must always remember that the factual possibilities of what could happen when it comes to restrictive covenant is endless. In Kumulis's restriction was not based on the number of years. It was based on the fact that, look, the guy was brought from Cyprus. They were manufacturing brakes for cars in the whole of West Africa. Now, he went to, when he left Leventis, he was going to another place within the sub-region of, and what the Supreme Court said, these people are also functioning there. You cannot go to a competitor. Now, we always think that it stops somebody from working. It does not stop somebody from working. You can work somewhere else as long as it is not competing with that line of business. I think what we don't do is to look at the effect of these things on companies and their secrets and their profit margins. I mean, it's not a conversation for today, so I will leave it at that. Thank you.
Okay, sorry. Thank you so much.
I know the learned speak was disagreeing. We have some time.
Yes. I listened to him.
We are really out of time, and we need to take questions from the audience. And I'm quite certain they are going to revisit some of these issues as well.
Yes, so lucid point made, the gentleman was not allowed to operate within the same geographical radius for how long? see, can I say this? You see, contract and restraint of trade, large and arguably inexhaustive. It could operate in different ways. What is the philosophical underpinning? The philosophical underpinning is the length of time, the contractual counterpart. In certain instances, it need not even be an employer. The case that started it in the English case was not even an employer-employee, it was a dealership. So it's almost the same thing. The point is labor mobility. For how long, because of the factual scenario that you put up, are you allowed to restrict him from putting up a similar station, from disclosing this, from using this for his own benefit to be able to earn income? That's the whole thing. So that is the common thread that you must always think through, that contract or restraint of trade try to restrict. And when you go see all the cases, yes, I mean, the peculiar fact will always throw up a few things and all of that. But the most important thing is that what the law, or I'm sorry, what the contract seeks to restrain and which the court will find reasonable or not is the length of time. Reasonability test is against the length of time, as opposed to what is that issue that you are seeking to say nobody should get to know of. That's the point I'm making about that. And that is where I disagree. And I'm happy to be educated further. That there are other instances where you don't even take that into consideration, because that's, for me, is the sole thing that we consider. I've also said, let me quickly address this. Yes, it's correct to say that. Yes. All right. No, I just wanted to chip in a point that that was made by a commentator that at the time that decision was made at the lower court, that act had not come into operation. It was no, that's not correct. That act, as at the time was coming, that act, but the point is that it was not brought into focus. It was not discussed. That's not correct. It was not discussed. And it is to that extent, well, it is arguable to say not reaching Painkuriam. It is arguable, but when we get to really understand the meaning of Painkuriam and saying that your distribution cases, you will see that they are all within the same bracket. The most important thing is that the court, if this had come to the attention of the court is very likely to have
very differently. Thank you so much, sir. Thank you for that intervention. And my final question to Nancy will be in respect of the industrial relation policy. Yes, we know that there are legislations, there are policies and regulations passed from time to time, and specifically this industrial relation policy is aimed to foster workplace harmony. But in reality, organized labor is of the opinion that is a bit restrictive. The intention of that policy is not being achieved. So from your perspective, having seen this policy, do you think this policy advances social dialogue, or do you think it's just come to, constrain collective action that, the organized labor would ordinarily have deployed? And then you will pardon Nancy that camera is off at this time. Nancy, can we have you?
The truth about this industrial relation policy, I'll be very sincere, they have a very good intention. But what would look at, but what would consider is the impact in practice. For example, now the policy is saying they are going to promote tripartite, where they say there will be dialogue between employers, the government, and employees. So it's also talking about early resolution of workplace disputes. Also talking about tripartite consultation, such a way that you don't just move straight. You have to find a way to resolve this issue. So these objectives, if you look at it, are really, really positive. But if it's not applied properly, it can actually reduce or even reduce the industrial dispute. If it's applied positively, if I actually applied positively, you could see that it could reduce the industrial dispute. However, you could see that organized labor concerns are valid where dialogue. You could see that organized labor dialogue are actually valid where this dialogue is used to delay actions. Most time we could see that they're actually trying to do this, but in the essence they're trying to delay actions. Let me give, for example, A worker complains about unpaid salaries, and management will say, oh, we're looking into it. You could see continued dialogue. Under the policy, they have like several meetings, but they fail to have a clear decision. They keep having meetings every time. Oh, we're looking into it, we're looking into it. Months to pass, workers remain unpaid. And when union considers strike action, it's actually told that you should return to dialogue. In that situation, dialogue does not resolve any dispute. You could see that it's delaying justice. So we could actually see that it's actually another example we'll look at is when workers raise serious safety concerns. Instead of negotiating the binding safety measures, the employer relies on repeated consultation meetings. Oh, we're actually getting an expert to do this. When discussion continues, unsafe conditions, we see actually unsafe conditions still remains. In the process, maybe one of the employer actually injures, and nothing has been taken. They actually wait when an employer injures and all that. They actually go to union, and here you see that dialogue has actually replaced collective bargaining instead of supporting it. So, like I said earlier, this particular policy has good intention. But what we'll look at now is that the concern. So there's also a concern about these policy procedures when it's more difficult to union to exercise their lawful right to strike. So these are the kind of things we'll look at. Maybe workers may actually issue like proper notice after failed negotiation. So, but you could actually see that they undergo further consultation, even where there's a clear outcome, as in where there's actually a clear outcome. So in my view, I would say that the policy is actually promoting social justice in principle, but it's risking the limitation of legitimate collective action. If dialogue does not meet this good faith and clearly timelines are not enforced, you could see that the particular intention, because like I said, the dialogue, we have to look at the intention. Is intention, what actually is this intention? Is social dialogue there to strengthen collective bargaining, or is it there to come and replace it? These are the things we'll look at. We'll also look at whether this dialogue will lead to action or whether the dispute will reduce. What is the benefit of this this particular dialogue to us? Is it here to come and delay solutions or even breaks it down? So we'll look at all this because the policy now, if you look at the paper, the way it's well written and all that, to be sincere, it's actually promoting dialogue on paper. I would actually say the truth. But dialogue only works when there is good faith. Because if someone comes to you and give you that particular trust, and that particular trust, so the good faith is no more there again. But if dialogue becomes like they want to use this dialogue to such a way that to deal with union, to make sure that union delay actions. So when union comes say, no, we are still dialoguing. So a lot of things have actually not been done. So if this dialogue becomes a tool to come and delay action, whether that resolve problems, like I said, it stopped being dialogue. So you could now feel that it's more like they want to come and feel control. So dialogue for no reason should it come and replace collective action. It shouldn't come and replace it. In my opinion, it should come and complement it. So the policy is good. It is very, very, very good. But would want to see why is the policy there? Is the government using this particular policy to turn the union? Are they tired of the strike? Are they tired of, wake up in the morning, there's a strike? And so a lot of things we have to look at more than what those people are offering us. Because if you go to like countries that countries that are actually working in such a way that the government will tell you A is A and B is B. But we all know that in our country where we are now, like the ASU strike we talked about, if the government actually looks at this agreement, because the government just wake up in the morning and put up something on paper without even put up something on paper without even capturing it in the bill. Without even capturing it in the budget. So for anything about dialogue, they should trust. The employees should be able to trust. This is what what are the intentions of the government? Is the government here to stop industrial action? They are tired of the embarrassment. They are like every time they're seeing ASU strike, they're seeing all this strike, only Nigeria. Is the government tired of all those things, all those problems? The government is wants to fix the problem, then that is actually good. But if they're trying to do this just to reduce the power of the union, reduce the power of the employee, we should find out that this is actually a fundamental right that they cannot even stop. So we must look at the intention. But notwithstanding, on paper, the dialogue is really, really good. And they've actually done a good job. Yeah. Thank you very much.
Thank you so much, Nancy. And sincerely, when trust is eroded, you realize that relationships begin to have a a breakdown irrespective of the terms, that are put forward from time to time. And of course, this then brings us to the questions, that have been posed by persons in the audience. We have questions around the restrictive clauses, and some persons have tried to juxtapose it with trading bonds. So I would ask of Learned Silk or Mr. Bello to speak to these questions, since they seem to have so much interest in it, and ensure that they had a bite at it when he initially asked. So Max has a question which says that would trading bond also come under restraint clause AMA of the SFCCPA? I mean, just a two kind of sentence response will do.
Yes, it kicks in post-employment. And so a typical situation is the gentleman has been sent on some overseas training to function in a capacity that when it comes, it will make him attractive to competitors within that particular sector. So usually what happens is that to ensure that it continues and the employer gets benefits on what he's investing on for the training. He enters into a training bond that, the totality of these, when it comes, is going to remain in employment for this number of years. So my understanding with the FCCPA Act is that you can't do that beyond 2 years. So the question is, there are certain training that would, the exposure of the employer, no doubt, would clearly go beyond getting the benefit of 2 years. What I think one needs to do within the position of the law is to, the employer needs to just hedge the risk and maybe limit the sort of exposure, or the sort of training that will cover, or look for a way to deal with this in some other way. This is a question that I've also had to think through in light of what would appear to be a position of the law, whether parties can contract out of statute. The question the answer from case law citation is yes. But when that statute has a penal provision for it, you can't contract out of it. Also from case law citation. So since there are provisions that would seem to say that it runs foul of the law and then cannot be upheld, I would say that still is to avoid it within the letters of the law anyway. Thank you.
Thank you so much.
At this point,
you have to exit.
Yes, thank you so much.
Thank you so much.
Maybe I should say I don't agree with you.
Yes.
I also don't think that, even though bonds may be a shred of restrictive covenants, their intent are quite different. Bonds are not tied to trying to say don't go to a. In fact, you can go to a competitor and work for bonds, but what I'm doing is, look, if I send you to a training, refund my money back before you leave me. If you can't refund me, you will have to stay and earn with me.
And work for it.
What is important here is that, because of the bonds cases that we did at that time affected pilots, you will see that the people who are bonded are not just everyday people, are not even bonded. So imagine, for example, that you, Titi, you are told that as you are entering this plane, the person who is flying this plane has just finished his training in France. This is the first time he is flying a plane. How would you feel?
I'll go by road.
Okay. So you see, these are the things. And you see, one of the things the MD of one of the company we're dealing with was telling me at the meeting was that, look, do you know that pilots who are flying, so people who have got incidences have not gone on this training, and this is why you have high increment in incidents relating to that particular airline. So you will find out that, look, what we are trying to legislate on with specificity of time is something that have a whole lot of variables. Those variables, you can't tie them. It has to be considered on its own merits. That's just my intervention. But the discussion continues at other forum. Thank you.
Thank you so much.
Thank you so much. Thank you so much. I was waiting for the extension, and I'm sorry I failed to see it. The point remains that training bond is a species of, and that's why I kept saying that, you're dealing with a wild and indeed a generic descriptive term that deals with instances where an employer affords an employee some opportunity that ordinarily would not, but for certain reasons, and says that if you fail to either pay me the costs and you decide to leave within a timeline, you either pay me the full cost or you cannot leave within a timeline. That is the restraints. So there's a need to understand it from that perspective. So that's where the restraint kicks in. Now, condescending on the particular fact that, you could either pay or leave will depend on facts, from particular fact situation that you deal with in every circumstance that comes up before the court to the order. But again, even at that, you need to consider that if it's a payment back, that is the option now. Again, the law still looks at it that you consider that vis-a-vis the number of months or years that the individual has given it, as opposed to what you find in many training bonds that would not try to prorate as against the number of time and will be asking for the full sum. So, but again, we're just dwelling into what we need not when we're looking at what is the whole essence of restraints of trade and what is the law. Yes, what is the law as of today around it? Non-compete,
thank you so much.
Training bonds, there are many, but at the end of the day, they all fall within that generic of restrictive covenant. Thank you very much, Ron. Thank you. Yeah.
Thank you so much, sir. And just to ask, thank you for your time. We are very grateful, Learned Silk. And I have a further question riding on that. About consideration. Usually we talk about there should be consideration for any. I mean, you should get something for such a restraint. And of course, there are decisions of courts already that if the restraint comes after you've contracted, the consideration must be very clear. To come in. And the question here is, where does consideration for such compromise sit in determining the balance and the legitimacy of this contractual arrangement? How do you bring this up consideration?
Let me come in here. And you see, my approach to these things come from a thought process that seeks to suggest that restrictive covenants or training bonds are what you will call collateral contracts to a main agreement, right? So if you have an agreement with somebody, you must have offer, acceptance, consideration, and all those things that that don't vitiate the contract. Now, if you have a further contract extending blah blah blah, a collateral contract may be that it's an additional contract that also Now, one of the problems I have when people say you must add consideration to make a bond or
validate
it. Honestly, it does. I will tell you why it doesn't make sense. Those contracts are not collateral contracts. They are not. They are incidences of employment. I cannot offer two considerations for one contract. It is impossible. And in any event, the consideration inheres in the nature of the contract that whether it's a bond or a restrictive covenant seeks to achieve. So to ask me for a fund, and let us go and look at all the cases, whether foreign or Nigerian. At least when I say Nigerian, I mean the case of Komulisa and Leventis. The condition of having another consideration was never discussed. It was never discussed. We are treating it, in fact, if you look at standard employment of top management staff, like an MD, like a CEO, chief operating officer, and all those things, a restrictive covenant is embedded in their contract of service. And the way it functions is like this. When you are giving your notice that you are leaving, there is already a garden leave. That garden leave may be for 1 year or for 6 months. In that garden leave, you're not doing anything. In fact, you are at home. But you are collecting salary for not doing anything. Where do you put that as a consideration? It discusses that. And I think people don't really understand how these things work. The way it works is that, look, we're not putting you out of job. In fact, within your garden leave, you can work somewhere else that is not a competitor and I will still pay you for it. So I think it must be understood from the aspect of what is the intent of a restrictive covenant. Now, I agree with the fact that, look, you cannot rush a contract to somebody to sign. I agree with the fact that you cannot put in some unhealthy actions, to blindfold an employee into signing certain things. Those are duress. Those are things that appreciate. But to start adding consideration, I think for me it makes sense. And I will share again a write-up I have done on restrictive covenants, and particularly when the first case of, like I said, when the NIC decision on it came out, I looked at it and I went into town to see why the Court of Appeal was going to overturn. And I'm not surprised that it was overturned at the end of the day.
Thank you so much, sir. Thank you so much. We've taken the questions we could take. We are running out of time. And I want to ensure that, we go through all the questions. So I believe all the questions that have been brought to my attention, I have taken them. At this time, I will be handing over the session to our founder and trustee, Mr. Jamiu Akolade. I don't know if he's still on the call.
Yes, I am, Titi.
Jamiu, are you with us?
Yes, can you hear me?
Okay, over to you, sir. Yes, we can hear you loud and clear.
Okay. Good evening, everyone, and thank you for finding time to join us this evening for this session. It's been almost 2 hours of rich conversation and updates on employment and labor law. If you've seen the advertisement for this webinar, you'll notice that it's meant to launch our flagship publication, the Employment Law Year, which is in its 5th edition, I think, where we review the past year in labor and employment law and then provide a prediction of what we expect in the new year. If you've registered for this webinar, you should get a copy of that publication by email. Otherwise, you can also look out for it on our website, elan.com.ng. Elan's membership is open to all lawyers qualified to practice law in Nigeria and who have interest in labor and employment law. As such, we would welcome any intending members to join our association if they so wish. You can also indicate interest in joining by visiting the website and click on the join link and you get further directions. What I would just like to highlight are things we should expect from Elan in this new year. There'll be a lot of capacity development programs. We're starting our employment law school this year. In February, there is a mediation training, 2-day mediation training coming up in collaboration with Fotepa Academy. Details were provided in the chat room, and again, you can go to our website to check for our upcoming trainings. The field of labor and employment law is a very, very dynamic one, and that is why practitioners and those who are affected by developments need to pay special attention. So we recommend our trainings, our webinars. This one is free, some are not free because we have to bring in specialists. The trainings will be running throughout the year. And you can also go on our website, read different publications and past webinars on the issue. Also to note that apart from the trainings, Elan is going to significantly increase its capacity to carry out its public interest, advocacy, mandate. If you've been monitoring our activities, you will notice that last year we filed an action to enforce what we consider to be unfair labor practices in a factory somewhere in Ogun State. That case is still going through the court process. But what I want to highlight is that Airline has a workplace support scheme where we receive requests for legal assistance by indigent persons, by corporates, and by employees generally. And what we do is to match those requests with our team of members and law firms. At present, we are handling close to 20 cases. Some of them will be coming up for judgment as soon as January this year. So I want to appeal that wherever we come across unfair labor practices, or if we know people who need specialized expertise in labor and employment law, Airline is the place to seek that expertise. I'll be happy to support. And on that note, I would like to formally close this session to thank our able moderator, Mrs. Titilola Olatunde Fashogbon, Senior Associate in Udo Udoma Bello and Osage, one of the top law firms in the country and one of our supporting firms for our workplace support scheme. Mr. Gbenga Bello is an associate director in IHS, has extensive litigation background before he went in-house, and is also one of our leaders in Airline. The Leonard Silk, who couldn't wait till the end, unfortunately, is also one of our leaders in Airline. So you can see that within Airline, we don't need to go outside to get resource persons. Airline's membership is so rich. We have senior advocates, we have very senior lawyers, we have professors of law, we have HR people who are lawyers, because I know a lot of HR people keep saying we want to join, but you have to be a lawyer to be in Airline. So I want to thank you all. I'm sorry, Dr. Nancy Nzom, forgive me, is also a member of Airline, and we are happy to have all of you. Hopefully this webinar will happen every January to review that publication. And we hope to have you next year and for the rest of this year for all the events and goodies that Airline has to offer. Thank you very much, everyone, and have a good evening.
Thank you, Jamil. Thank you very much, Titi. Well done. Well done.
Thank you, sir. Thank you for the time on the call. Thank you.
Well done.
Thank you.
See you.
Thank you, everyone.
Thank you.
Bye, everyone.
Bye.
Bye.